Welcome to the Neighborhood Law Center. I'm your host, Melvin Burris. And our topic today is, what do you need to know about buying a home? Our guests are my daughter, by the way, our special guest, Tamitra Burris, attorney at law, and our distinguished guest from the last show, Larry Miller of Miller Law Group. Welcome.
Thank you.
Okay.
Good to be here.
Tamitra Burris, would you mind telling the audience a little bit about yourself?
My name is Tamitra Burris. I am Chief of Staff for Commissioner Rogers at the Cook County Board of Review, and I deal with property tax, assessed valuation, and appeals for a quasi-judicial agency.
Okay, thank you. Larry, Attorney Miller.
Okay. I'm Larry Miller. I'm president of the Miller Law Group, PC. It's a general practice law firm. We have three basic divisions. It's a bankruptcy division, which is debtor-creditor, and we have a real estate division, and we deal with all aspects of real estate, whether it be a short sale, a purchase, a sale, a reverse mortgage, and then we have a general civil division.
Okay, thank you for coming out. Well, I was talking to some of my viewers recently, and one of the things they were saying, Mel, we have been thinking about purchasing a home. What are some of the things we need to know about buying a home that we don't normally read in these how to buy a home books? So, Attorney Miller, could you kind of give us a little help there? What are some of the things buyers need to know when they sit down to sign a contract?
Well, you should have a very knowledgeable agent to help you with that. You should also have in mind who your lender is going to be. Try to have some pre-qualification, so that will speed up the process, because to get a purchase closed anymore, it takes somewhere between 60 and 90 days, if not longer, because of all the requirements that have now come in since the crash back in 2007. You want to make sure that you have sufficient provisions in the contract. You may even want to have it reviewed by an attorney before you submit it, and that may be the same person that you want to do your closing for you.
Mm-hmm. Okay, you mentioned provisions that you need in a contract. Can you expound on some of these provisions, contingency, and other things that you need in there?
Well, one of the things you really want to make sure that you have is a contingency about financing.
Mm-hmm.
Because if you don't have that in there, you're buying a house and they're expecting you to pay cash for it with no financing. So that's one thing you're going to want to have there. And you can even specify the type of loan, whether it be a VA loan, an FHA loan, whether there be some sort of seller financing involved, if it's going to be a conventional loan. There's all kinds of things to put in there, and an agent's going to know that and where you're at, and that's where the pre-qualification will help.
Okay, now, when the viewer was asking me about, can I get repairs put into my contract rather than buying a home as is that possible to put in repairs or other renovations that you wanted in the house before you purchase it?
You can put that provision in there. You should also get a home inspection. That way you know if there's any issues that might need to be repaired. A lot of times sellers will want to limit their liability or their responsibility for those repairs, and they'll limit it at $1,000. And you're going to want to know what those costs are going to be, and that may have an impact on your ability to buy the property or to get the financing.
Okay, now what about, like they said, do I pay the closing costs, or do the seller pay the closing costs, or is there a combination there?
It's a yes.
Okay.
You can either pay the closing costs, the seller can pay the closing costs, or it can be a combination, and you can specify what amounts those are going to be.
Now, why would I as a buyer want to pay closing costs?
Part of it is going to be deductible for taxes for you.
Mm-hmm.
Part of it is it may reduce what you have to bring for your down payment.
Okay. What about a survey? Is a survey included in that, or who does the survey?
A survey is not included in that. Normally that's going to be a responsibility of the seller, but if the property's been platted, a survey has been done, and you can have a survey affidavit signed off by the seller that there's been no major changes to the property, no encroachments, no changes in the boundaries, no fences put up, no outbuildings put up, no storage sheds put up. Those type of things are what you're looking for. If it's in a subdivision, a survey will already be done and a plat will be filed.
Okay, now, what if my buyer was telling me, what if I change my mind? Where do I go to get directions on, walking away from this contract? Is there anything in the contract that says that I can walk away or can't walk away?
Once you sign the contract, you're pretty much committed. However, if you have the contingencies in there regarding the repairs, or subject to financing, or subject to a certain loan, or subject to a home inspection, there are a lot of things you can put in there, subject to the seller paying all of the closing costs. And if those provisions aren't met, that gives you grounds to walk away.
Okay. If there's termite damages, will the seller pay for that cost?
They'll have to have it treated, and then it would be smart for you at that point in time to continue the treatment process or the inspection process, because it's not that expensive and it will eliminate any future damage.
What about the deed? What type of deed usually goes along with a contract like this?
You want a general warranty deed, because that's going to give you some protection and guarantee going back before the person who owns the property now.
Okay. Well, since you're talking about deeds, give us a little overview of the types of deeds that can go into a contract.
Virginia still follows the old common law adage of tenants by the entirety. And tenants by the entirety is kind of chauvinistic, kind of out of date, because it refers to a man and a wife. It has to be a man and a woman who are married. It can't be somebody who lives together. They actually have to be married, and they're treated as one entity. And it provides for a right of survivorship.
Okay.
It's also exempt from your creditors too, unless it's joint debt.
Okay. What about a quick deed? What is that?
Quitclaim deed will convey any title, if there is any title, by the person who's signing the deed conveying it.
Okay.
There's no warranty of title.
And the abstract. Why and what do we need in that?
That's usually done by a title examiner who goes to the courthouse, the circuit court clerk's office, and will review the deed book records and see what's there. They'll look for judgment liens. They'll look for any potential claims outside of title, any liens against the property, if there's any zoning issues, if there's any easements across the property. And normally, when I do a closing, I look for at least a 40-year search. Sometimes if the property hasn't been conveyed for a long time, I'll look for a 100-year search, because we find on a regular basis people have just conveyed property without actually having a deed, and they just let it pass down by descent to blood relatives. And a lot of times that creates a lot of problems that need to be taken care of, which is why you need to buy title insurance.
Okay. And that's the question. Why is title insurance needed?
Lenders always require title insurance, and they require the amount of the loan. If there is some title issue, the lender gets paid off. You may lose the house because you don't have anything to protect you. And this is a big investment. I always recommend that people get owner's title insurance, because it will protect you. If there is a title claim that's made, you're protected. The lender's getting protected. Why wouldn't you want to be protected? It's a little bit more expensive, but it's a one-time premium, and it protects you for the life of yourself regarding that property.
Okay. And how should the title be titled, I say, or held?
If it's a husband and wife tenancy by the entireties, if it's people living together that are not married, joint tenants with full right of survivorship. If it's people that are just buying a house together, they can have it as tenant in common. But when they're tenants in common, their share of the property can be sold, and there doesn't need to be any consent from the other co-tenant.
Okay. Well, now we're getting around to, I have this contract, and as we all learn in law school, the provisions are in the four corners of the contract, and that's what's guide you through the whole process. But outside of that, why do we need a survey?
A survey
And-
needs to be done because there may be some issue that's there. There may be some violations of the homeowners association. You might have somebody who is encroaching on the property. A lot of times it's where there are fences that they think they're on the division and on the boundary line between the two lots, and a lot of times they encroach. And you want to make sure that's taken care of.
Okay. We talk about easements. Could you expound on that? What are my rights and obligations under an easement?
The easements are there for a lot of things. It can be for public utilities, it can be for electricity, it can be for ingress or egress to the property. There may be some property that's nearby that's landlocked, but you want to make sure those are there, they're in the right place, because that could have some impact on the value of the property. Additionally, if your property is serviced by public utilities, you want them to come on and fix it. You don't have to bear that expense on your own. So that's why you have the easement there.
Right, allow the utilities and telephone and people folks to come on and do what they need to do.
Right, to keep the utilities functioning.
Now, the biggest thing, I guess, is, you purchase a piece of land, and there's trees, fields all around it. What guarantee do you have that it's always going to be that way?
You don't.
Okay.
There's no guarantee.
Well, what can I do, or can I do anything to get some confidence that the land won't change, things around me won't change as much?
You really don't have any right to do that because the people in this country have the right to do with their property what they want. Now, there are certain things they have to follow in order to do things, and you will get to participate in that. But basically, the landowner has the rights to do what they want to do as long as it does not violate any zoning provisions or any other aspect of law.
Okay. Okay. May a buyer request that the seller make, well, we talked about this. Can he put in there, seller, I want this wall fixed? Or if I'm hesitant to purchase a home because we talked about termites, we have flooding down. We find out there's flooding down in the cellar. Can I request him to make sure that the cellar is waterproof?
That can be a request. They may or may not do that because that can turn into a very expensive proposition. And if you've got that type of issue, like there's water in the basement and it's flooding, or you have a mold issue, that's something that you don't want to have to deal with. You want to be relieved from that worry and relieved from that expense for making that repair.
Okay, one question I guess Attorney Burris came up with is what is the attorney's responsibilities if the attorney is the attorney for the buyer when he's purchasing that home?
The attorney for the buyer is trying to protect the buyer, advising them, reviewing the documents, letting them know what is transpiring in the closing. A title company cannot do that. They can review the documents, but they can't advise you on them. They can't give you any assistance should there be issues with the contract not being fulfilled. They'll just tell you, sign here and notarize it. They can't tell you if this is a good deal, if it's a bad deal. Are you missing something that you should be concerned about? So you really need to have an attorney do that. If a title company does your closing and they advise you what you should do, that's the unauthorized practice of law because they can't really advise you what to do.
So every buyer, if they want to be responsible purchasing a home, should have an attorney with them.
They should. Title companies do work, and if you're experienced at buying real estate and you do it on a regular basis, you can get by with using a title company. If this is first-time buyer, I would strongly recommend you have an attorney because the attorney is going to represent you and help you get through the process. This is probably the biggest investment anyone makes in their lifetime is buying real estate, and you want to make sure that you're protected and you have proper advice and you know where you're at.
Okay. We're going to take a quick break right now. This is the Neighborhood Law Center. I'm your host, Melvin Burris, and our guests are attorney Tamitra Burris and also attorney Larry Miller. Our topic is the things you need to know when you're buying a home. And let's get back here and ask another question here. I have a buyer and a seller who failed to close on the closing date. There's a closing date. They failed to close. Does that mean the contract is null and void, or what do we do here?
It depends on what's in the contract. If the contract provides for closing on or about a certain date, it's got to be on or about that certain date. If they say it will close on September 30th and time is of the essence, it better close on September 30th because that's important. That's an important factor in the contract. So it really is important as to what terms are in the contract when the closing is set for. Because of the issues with getting loans right now, a lot of the contracts state on or about because that gives some flexibility because it may not occur because the underwriter for the loan may have some last minute request that you can't get done immediately.
Can the buyer put a penalty clause in the contract if the seller does not close in a timely manner?
You can. But they can also put one if the buyer doesn't close timely either,
Okay.
because they have problems with their loan,
Mm-hmm.
or getting title insurance, or there's something out there that causes another problem that is not really the fault of either, but it prohibits them from closing.
Okay, so this is all part of the contingency that we want to make sure that's in our loan. on our
That's correct.
contract.
That's correct.
Okay, so I buy into a contract and he decided to cancel the contract during the inspection period, but never provide a reason. Does he get his deposit back from the seller?
It depends. Probably not,
Mm-hmm.
because you're going to have a specific reason why the contract should be voided.
Okay.
If you can't have that particular provision, like it's because the financing didn't occur or the house didn't appraise for the proper value for the lender to make the loan, then you can cancel it and you get your earnest money back. But if you can't specify a reason, you just want to walk because you have buyer's remorse, you could be exposed to not only forfeiting your earnest money deposit, but you could also be exposed to liability and sued for specific performance.
Okay, so we purchase this home, and we're gonna let Attorney Burris now tell us about what happens with my tax assessments, because there's a tax assessments once you buy a home. What happens when my tax assessments keep going up? Do I have an opportunity to contest it?
Absolutely.
Mhm.
So part
Well,
of
tell us from the beginning what tax assessments are and what the review process is.
okay. So property taxes are one of the biggest expenses that you factor in when you're talking about the cost of home ownership. It's something that's going to continue year after year, and it's important to understand where it begins and kind of where that value is coming from. So a property assessment happens at a local level. It's usually through an assessor's office or some other assessing body on the local level. And what they're going to do is they're going to look at the property and they're going to determine what market value is. And in some jurisdictions, the assessment is a percentage of whatever that market value is. In other jurisdictions, the assessment it represents 100% of what market value is. So the assessors are going to determine what that market value is, and then the taxpayer has an opportunity to review that proposed assessment and then determine if they feel that the proposed assessment is accurate or not. Some of the ways that they look to see if those proposed assessments are accurate or not are, what did they purchase their home for? Is this proposed assessment reflective of what they purchased their home for if their home was recently purchased, say within the last 3 years? Or is the assessment reflective of market value of their home of something if they have a recent appraisal? They recently had their home appraised and the proposed assessment is not in line with what an appraiser has said their market value is. So those are some of the considerations determining whether or not that proposed assessment is something that the taxpayer feels is in line with what their true market value is. If they feel that the assessment isn't in line with what their true market value is, then they have the opportunity in some jurisdictions to go directly to the assessor and file an appeal or a complaint, or in other jurisdictions, they go to the next body.
Okay, well, thank you. Attorney Miller, you have something to add to that?
In Virginia, what they do is they look at the prior sales history of the property. They'll also see what houses are selling for in that neighborhood. And sometimes they really have no basis because they just do a drive-by. They don't really go look at the property. That's why an appraisal will be a better tool for you to use to make your argument regarding your assessment, because the appraiser actually goes in the house. And they'll have a better understanding of what the value is because they were actually there instead of the county employee or the city employee who goes by and tries to establish a value, because they have very limited time to do that. They're very limited with the number of employees that do that, that are qualified to do that. So they have to do a lot of those in a short amount of time.
Okay.
And this is particularly true in larger counties where they tend to use the mass appraisal technique. So sometimes they don't even drive by. They're just looking at values in the area and then making their determinations.
That's correct.
Okay, so now we're in the house. We're living there. We have these tax assessments. We feel that the tax assessment is higher than what my home, for instance, in 2006. property values are tremendously high. In 2008, they were very low of 2009. But yet, municipalities were still using the 2008 assessments. And so when that happens,
So part of the problem is there are reassessments that occur. Generally, some places reassess every 3 years, some places reassess every 4 years. So what happens is whatever those cycles are, that's when the property is reassessed. And those values tend to stay during that reassessment period, whatever those years are. So sometimes if property values are changing dramatically within those periods and you're still within that assessment period, some of that information isn't captured. So that's why it's important to be diligent and look at your value as compared to what your proposed assessment is, because if there has been great shifts in value, specifically downward shifts in value, because that's what most taxpayers are concerned about. If there's a downward shift in value, you want to be able to substantiate that and provide evidence that there's a downward shift in value and that your proposed assessment is no longer accurately reflecting what market value is of your home.
okay, well, thank you. Well, we're getting close to the end of the program. So let's kind of wrap up a little bit. Attorney Miller, anything you want to leave with the audience on purchasing a home?
I think the way you want to consider that is this is the biggest investment for probably 90% of the people that live in the area. And you need to make sure that you're adequately represented, that you get all the proper information. You're looking at a loan document package that's somewhere right around 100 to 125 pages that is talking about what interest rates you're paying, what your payment's going to be, what are your requirements under the deed of trust. And you want to make sure that you understand that, or you have somebody who can explain it so you can understand it. And you can ask questions and receive advice. And I would also suggest that because of all the foreclosures that have been going on, and I think we're going to see another ramping up of that again, you want to get owner's title insurance on the property because it will protect you. Because the lender wants to be protected, why wouldn't you want to protect yourself?
At market value.
At market value. And we have the company that I have the title insurance written through has an advanced policy where you can increase or decrease the value based upon the assessments, and sometimes you have to pay an additional premium, but you're allowed to do that, and it will provide you enhanced coverage.
Okay.
Property taxes are an important cost in home ownership. It's important to be diligent to monitor what your market value is as in reference to the proposed assessment. There are mechanisms in place. You can file appeals at the local level with the assessors, and if you're not satisfied with the result of that, you can escalate that appeal to a board level, whether it be a board of appeals, a board of equalization. It depends on what your jurisdiction has. And if you don't like that decision, you have another option to take it to the court or a state level.
Okay. Well, one thing we did not talk about was disclosure statement, which is very important
Right.
in real estate, even though it's a separate document from the contract, the four corners of the contract. But could you tell us audience a little bit about that disclosure and what it means?
Well, the disclosure portion of the contract is things that are known by the seller of the property regarding any issues that are there. A lot of times people will say there's nothing wrong with it when in fact there are things you can find that are apparent and it should have been disclosed. That's also a reason to get out of a contract because the seller has failed to disclose issues that they were aware of or should have known. That's why you want to have a good real estate agent, because they're going to have the time to check that all out and they will be working for you. And as a buyer, it's the seller's responsibility to pay the commission. So you can have a real estate agent and it is no cost to you. It's the seller's responsibility to pay the commission.
Okay. Let me ask you, one thing is we didn't talk about, it's very important with HUD, is the RESPA, which is the Real Estate Settlement Procedures. Now that's very important when you're a first-time home buyer, even though you're not a first-time home buyer. Can you tell us about that?
Well, there are certain requirements that have to be fulfilled in order for it to be a closing. Virginia does a wet settlement, which means you have to have money available, either it be wired or you deliver it or some way that the money is there. And when you sign the documents, you exchange the funds, and then you receive the deed, and it's upon the buyers to go file those documents and record them in the proper place.
Okay. One thing is one of my viewers that call and ask me about the truth in lending. You know, what interest rate am I really paying? Because they see 2 or 3 different interest rates. Could you explain to them the APR and the interest rates that's given to them?
What you have with the APR is it's the amount of money based over a certain period of time. They try to, it's kind of confusing if you really don't listen to it, but the Truth in Lending provides the annual percentage rate, and it's usually based on a shorter time than 365 days. It's usually right around 360. They discount some of the holidays. So your APR is going to be a little bit higher, but when they quote you for your amortization, they give you the interest rate based upon 365 days. So that's why there's a difference in it.
Okay. So we're wrapping up. I'm Melvin Burris. Thank you, Attorney Burris, Attorney Miller. And I want everyone to understand that it's a very important when you first purchase a home. Yes, we want you to get to a real estate person. Now, there's a broker and there's an agent. Now, what's the difference between the two?
Broker is usually the owner of the agency, and the agent is an employee, actually an independent contractor of the agency.
Okay, you mentioned before that who pays the real estate person? Does the buyer pays the real estate person, or is it the seller?
It's the seller who pays that.
And who's the agent working for?
Agent's working for you.
The agent's working for me as the buyer,
Right,
but the seller's paying them.
right.
Okay. So it seemed to be a discrepancy there, because why would, if I'm being paid by someone, but we'll figure that one out.
That's a whole other program.
Okay.
The thing about buying property, though, is good is that's really the last tax deduction you have for your income taxes.
Right, that's a good point. Well, thank you for watching. This has been the Neighborhood Law Center. Our guest has been Attorney Larry Miller from the Miller Law Group, and my daughter, Tamitra Burris, attorney at law, and I'm your host, Melvin Burris. Please look at us on the web, because we're on the website, www.neighborhoodlawcenter. We're also on YouTube, so hit us up on YouTube, Neighborhood Law Center. And if you want to get in contact with me, my email is maburris@aol.com.